Hi, everybody. Good afternoon. My name's Aisha. Thank you. My name's Aisha Bell Hardaway, and I serve as the director for the Social Justice Law Center here at Case Western Reserve University. I'm grateful to see so many people in the room today on a Friday afternoon, a cold Friday afternoon, and I think hopefully we're in for a treat here. The Social Justice Law Center serves to ensure that students at our law school interested in the contours of American inequality have access to top-notch legal educational offerings and experiences. For far too long, law schools around the country have failed to recognize the inadequacy of the legal education system that ignores the ways in which inequality is baked into the brick and mortar foundation of the American legal structures. The Social Justice Law Center aims to meet the curricular interests of our law students here at this law school, motivated to understand social inequities created and reinforced by our legal system. And so we are really excited about the opportunity to participate or be a sponsor along with the Institute of Justice for this discussion today on qualified immunity. We're grateful for our esteemed panelists who have come to share with you their thoughts on the ways in which qualified immunity are impacting the ability to seek justice and reform the practices in which people are looking for remedies here in our country. So we thank you all for being with us. I'm going to get out of the way so that the panelists have plenty of time. I think our goal is to be here with you all for until a quarter till, and then do 15 minutes of Q&A. So in the audience, to the extent that you all have questions, we will have Q&A starting at about a quarter to the hour. Thank you so much.
Well, thank you for that introduction, Professor Hardaway. You already did the most important part of my job, which is encouraging people to start thinking about the questions now so that we don't get to the Q&A and hit that awkward silence. And I really do want to thank Professor Hardaway and the Social Justice Law Center and Case Western for your hospitality and working with the Institute for Justice and having us here for what is a really important and timely conversation about qualified immunity. We're going to hit a lot of different aspects of the issue today. My job is to mostly get out of the way after these introductory remarks and make sure you can hear from our panel today. I'm joined on the far end by Andy Geronimo, who's the director of the First Amendment Clinic, the Milton and Charlotte Kramer Law Clinic at Case Western Reserve University School of Law. Many of you probably recognize him as a familiar face around campus. My colleague, Patrick Giacomo, who's a senior attorney with the Institute for Justice, focusing on our project on immunity and accountability, which focuses on government immunity and accountability, unsurprisingly. And very excited to have one of IJ's clients, Anthony Novak, and a Parliament native, who has firsthand experience with what qualified immunity looks like from an individual's perspective who's trying to seek justice for constitutional rights violations. So I think we've got an excellent array here of legal, policy, and personal expertise I'm excited to get to. I do want to just start very briefly and just acknowledge the situation in East Palestine. Many of you may have friends, family dealing with that situation. So personal thoughts and prayers are with those folks, and we hope for a speedy and safe and healthy resolution to that issue. I'm just going to go ahead and get started and jump in with you, Anthony, if we can, because I think most folks are going to be interested in hearing your story and how it relates to qualified immunity. So if you can take us back, I was looking at the date, almost exactly 7 years ago in March, you decided you wanted to make a Facebook page. And can you tell us what that Facebook page was, kind of what the genesis of that was, and then walk us through how that point got you here?
Yeah, so I was bored. Hi. I was bored at a bus stop as I left work. My phone, and I decided that it'd be funny to make like a parody page of my local police department, because my local police department at the time was not very good, so I thought it was kind of funny. And so I made a Facebook page, and it had a bunch of parody posts on it, and it was up for, this is a long story short kind of thing, it was up for about a day. During that period of time, they were on like local news, kind of talking about the page, and so I got scared and I deleted the page. And then about 3 weeks later, they arrested me, they raided my house, they blasted my mugshot all over the news. They arrested me for disrupting public services. Somehow by making the page, I disrupted their ability to do their job in a sense. And so since then, I had to go through a court process. I went through a trial even. It was a felony charge, so I couldn't went to prison. And then I beat that charge. I was found not guilty, and I've been suing them since.
And I want to start with that kind of 3 weeks after the fact when you found like, my apartment's being raided, they're taking my computers and stuff. And this is on the First Amendment component more so than the qualified immunity component before we even get there. But since we have two law experts on the panel, just from your perspective as First Amendment experts, kind of what's your gut check reaction to the first part of Anthony's story, creating a parody Facebook page, and then a few weeks later finding yourself on the other side of a police raid?
Well, the first thing that I think of is like the First Amendment operates in a lot of different ways, right? So regardless of what's on the books in terms of statutes or other common law torts or something, the idea is the Constitution is supposed to provide a safety valve for protected speech. So, the first thing that I think of is if the only thing that the arrest was based on was Anthony's protected speech, then there should be a First Amendment defense to that, regardless of if the charge is a criminal charge or a civil tort claim or something like that. So I think a look at that page and what it does and how it operates really should come with a high bar towards our long tradition in this country of protecting free speech.
Yeah, I put on my everyday person hat, and just to kind of take you guys to the post we're talking about. This was obvious parody. So Anthony's page said Parma Police, but then it had the slogan, "We know crime," and "know" was spelled N-O. And the posts were things like, we're recruiting new officers. You basically need to do a multiple choice and hearing test. Minorities need not apply. Things like this, like things that are very clearly not the real police department. And so when you see something like this, without even putting on your a lawyer hat, everybody knows that if the First Amendment protects any sort of speech, it's speech that makes fun of the government. And so that's it. That should be the whole ball of wax here. So not only should someone like Anthony not feel afraid to hit enter on their keyboard because they're joking about the government, but the thought that after someone like Anthony gets arrested and prosecuted and acquitted, and all of this shakes out in the wash, that at the end of the day, federal courts will say, well, that's just too bad for you. So therefore, you're the one that has to bear the cost of the violation of your rights, is the thing that drives me absolutely insane as a human being and as a lawyer.
And I think that kind of catches us up to where you left off, Anthony, which is you're acquitted, which has got to feel great at that point. And how long of a time period in your life was that, from sort of police raid to finally having the acquittal taken?
I think it was around 5 months, if I'm not mistaken. Five and a half.
Very stress-free 5 months, I'm sure.
Oh yeah, it was great. Just kidding, it's not.
Yeah. And so now, if you can walk us through your mindset going into the lawsuit, because obviously you've been acquitted, you did nothing wrong, your rights were violated. Were you just sort of assuming, of course, like someone violated my rights, I can go and ask a judge to acknowledge that and have some kind of remedy?
Yeah, and also I was still living in Parma at the time. I lived with my friend, I had a lease and everything, so I felt like it gave me some sort of safety too, because I didn't know what they were going to do now, because they were also kind of lambasted on the news after people saw what they actually arrested me for. And so, but I did think this was going to go a lot more smoothly. I didn't think I would be sitting here 7 years later in front of a panel like Case Western University hoping it continues.
And maybe if you can walk us back, and I don't know the exact way you found out that the case was being dismissed on qualified immunity grounds, but I don't know if it was a conversation with your attorney or you read it. Had you heard about qualified immunity before that point?
Yeah, I definitely heard about it.
Yeah. Was your reaction just sort of, oh, well, of course this happened, or were you surprised or shocked in any way?
Oh, I'm shocked, because it had gone on for this long. There were video depositions, the next step I was trial, and then suddenly it was just canceled, seemingly out of nowhere from my purview, due to qualified immunity.
And then, and I think the thing that makes it unique in Anthony's case is that one of the things that we can talk about that's so pernicious about qualified immunity is that, unlike a lot of other defenses and procedural hurdles, it allows the government, if it's denied, to immediately appeal the case. And so that's what they did in Anthony's case. Right off the bat, they appealed the case and said, we should get qualified immunity, don't let the case go forward at all. And there, the Sixth Circuit Court of Appeals said, no way, this is protected speech, it needs to go forward, and there's fact-finding that needs to be done, because the questions related to parody have to do with whether a reasonable person would realize that this wasn't true. And so they said no qualified immunity. It was actually, the opinion by the same judge, the second opinion was kind of a love letter to parody and free speech. And he said, this is American as apple pie. Everyone would know you can't do this, basically. So then the case went back down and moved forward. So more fact-finding was done. The facts show that it is exactly how Anthony had pled it. This was, all done without any fair basis and clearly based on free speech. And the thing that makes qualified immunity so jarring in his instance is now they appeal again before they even get a chance to go to trial. And the same judge looks at the same facts, although they're even better now, and says, well, actually, the posts are probably protected by free speech. But since there's not an earlier case here in the Sixth Circuit that says you can't delete comments calling them fake, that's enough to get the officer's qualified immunity. So that's what makes qualified immunity really, highlighted with Anthony's case. It's like, this is terrible stuff that happens in most cases, but you normally don't get this opportunity to see one judge say the exact opposite thing, a year and a half later because of these procedural mechanisms.
And if we get into the reasons often given for qualified immunity, especially from the governmental side, right? If you read the case law, the reasons that they give that qualified immunity as a doctrine has to exist are things like reducing the expenses of litigation, right? Not chilling public participation, not wanting to chill employees, chilling lawful conduct. I don't see how any of those policy reasons are served by prolonging this litigation on the qualified immunity issue. We're talking 7 years later. I feel like we're at a point now in terms of qualified immunity precedent where it's just we've undermined a lot of the reasons originally given for this doctrine.
Yeah, just to put a pin in it, in Anthony's case, which is representative, the fight that is now taking place and what we're ultimately asking the Supreme Court to do, which, by the way, they're sitting right now in conference deciding whether or not to take Anthony's case, and they'll tell us on Tuesday at least what the next step could be. All we're asking for is for Anthony to get to go to trial. We're not even asking the court to say you win, necessarily. I mean, that's what qualified immunity is really all about. Can this case even go to a jury to decide whether what happened was bad? And so in that way, qualified immunity is just a fundamental attack on our jury system, which is kind of remarkable if you think about it in that way.
And that's the perfect setup where I wanted to go next, because I have sort of intentionally created the faux pas of being in a law school and not defining our terms to sort of start the conversation. But now that we've kind of heard Anthony's story a little bit, heard how it has played out in the courts, I'd just like to take it back to you guys again. What is qualified immunity? We know it's some way for a court to get thrown out. I'm sure in a room full of attorneys and law school students, it's probably well known. But for anyone who's maybe not an expert, how would you describe this sort of strange thing that seems to end cases mysteriously?
Yeah, I'll take the first step. So qualified immunity is a judge-created doctrine that the Supreme Court made up out of whole cloth in 1982 for explicit policy reasons. And Andy and I were actually talking about this before the panel started. The policy reasons essentially boil down to we want to make it easier for courts to throw cases out because we don't like having to deal with all these cases. And by these cases, I mean people's constitutional rights that are violated. And in very short, the way that qualified immunity works is anytime you bring a constitutional claim against a government worker. So we talk a lot about police because police are sort of the most front-facing type of government worker. But this applies to every government official. Mayors, building inspectors, you name it. When you sue them, they have a default immunity from suit unless you, the plaintiff, can show that the right that was violated is clearly established. That's the legal term of art. And over the last 40 years, the court has defined that more narrowly to essentially mean you need to be able to point to a case that involves materially identical facts to yours. And if you can't show that there was an earlier case, we're going to grant these officers qualified immunity. And so Anthony's is a great example of this because plenty of cases say that you can parody the government. But as the Sixth Circuit held in throwing out Anthony's case, there's not a case in the Sixth Circuit that specifically says deleting comments on Facebook is a form of speech, and therefore qualified immunity applies. But we see this sort of hair splitting everywhere in the qualified immunity space. So there will be a case where a prison guard pepper sprays an inmate for no reason, and the Fifth Circuit throws the case out because although there were cases saying you couldn't hit or tase a prisoner for no reason, there was no case that said you couldn't pepper spray them. And that's an actual case called McCoy versus Alamu that actually the Supreme Court did reverse. But this is the sort of analysis we engage in. And by the way, just as a side note, we don't have to go down this road. The Fifth Circuit just issued a decision the other day where now they've added a third element that says even if it's clearly established, you, the plaintiff, still have to show that the government official acted objectively unreasonably in violating your clearly established constitutional rights. And so the bottom of this pit, at least I've been digging for years and I've never been able to find it.
And I think building on that, how it's gotten, the doctrine has gotten more and more powerful with certain Supreme Court decisions. And one that I sort of wanted to highlight is the Pearson versus Callahan decision. So it's a 2009 Supreme Court decision, and before Pearson versus Callahan, the questions in order was, is there a constitutional right at issue? And two, is that constitutional right been clearly established? Pearson versus Callahan, and I would encourage anybody who's interested in that to go this topic to go listen to that argument to hear how the justices are talking about qualified immunity. But that case sort of flipped that and said that's no longer a mandatory order of operations that you have to go through. So if you zoom out and say, in order for these individually named officials to be entitled to qualified immunity, there has to be clearly established law. Pearson versus Callahan allowed courts to say there's no clearly established law, and we don't have to find whether there's a constitutional violation here, which hurts you going forward, because if you never establish that there's a constitutional violation, how are you supposed to, in future cases, show a violation of clearly established law? So it's really, I think, perverted some of the reasons from it. And I was just listening to the Pearson versus Callahan argument the other night, and it's Justice Breyer and Justice Alito saying we need to give district courts a way to kick these cases out. We should be dealing with the hard cases up here in the Supreme Court, but what we want to do is we want to clear the chaff in the lower courts, and we want to give them an easy way out of these things, which, like as Patrick said, these are lawsuits that allege serious constitutional violations that are getting short-circuited and can't be heard on their merits.
Yeah, and I think I'm really glad you brought up Pearson, because Anthony's case again illustrates how this works. Here, what the court actually held was it's not clearly established that deleting comments is protected. So you lose for qualified immunity purposes. That means that we are also not going to decide in this case whether it is or isn't going forward. So at least in some cases, the courts will deign to say, it doesn't apply here, but we are now announcing that this is unconstitutional in the future. In fact, the Fourth Circuit just the other day decided a case that involved live streaming police where it did this. It said, live streaming police is protected by the First Amendment, and this will give you another flavor for the hair splitting. But since until now, all that was protected was recording police, the officers here get qualified immunity because recording ain't live streaming, my man. And so this is the world that we have to live in. But in a crazy way, the Fourth Circuit doing that was kind of throwing a softball to the world of civil rights, because now, at least going forward in the Fourth Circuit, live streaming is also protected in the same way that recording is. But thanks to Pearson, a lot of courts, like the Sixth Circuit here, can just say, hey, it's not clearly established, maybe it is, maybe it isn't, we're not going to say. And not only does that not allow the law to develop, it affirmatively shows that now in the Sixth Circuit in Ohio, if you delete Facebook comments, police can arrest you for that, because they know the Sixth Circuit has said it's not clearly established as a constitutional violation. So until the case decides that it is, everyone in this room is at risk. And I just think that this goes unnoticed in the qualified immunity discourse because it's so crazy. And there are cases like this. There's a case from California where police were accused of stealing money that they took while executing a warrant. And the Ninth Circuit said, well, everyone knows you can't do that, it's wrong, but there's not a case saying it's unconstitutional, and this isn't going to be that case either. So now police in the Ninth Circuit, until they change their mind, can steal money and at least not be subject to constitutional claims because of it.
So I think, Patrick, you set us up really well to start shifting into the kind of policy implications on government institutions. As you guys think about that, I do want to almost take one little sidebar, because the First Amendment is so crucial here, and on those comments you made about kind of changing technology. Again, as sort of First Amendment experts, is the First Amendment sort of uniquely at risk in these kinds of situations because technological change has made it so complicated? And does it open up new ways for people to kind of split these hairs?
I believe so, absolutely. Just because, as technology advances, so do the platforms for speech. Your opportunities for speech. It's you see it in the line of cases, right? In the early 20th century, these rag magazines aren't protected by freedom of the press, right? Or, this is a film, this is a movie. That's not That's not what freedom of speech is all about. And then, again, as the internet comes around and the restrictions on the internet, we're regulating conduct, we're not regulating speech. So I think, I do think that there's a great point there that if what we're doing is relying on clearly established law, and we're going to get to these levels of granularity about what a case within the circuit needs to say in order for you to clearly establish a right, those advances in the technology are going to make it harder and harder to push these constitutional points.
Yeah, and I think that's obviously very well exemplified by the case I just mentioned, Sharp versus Winterfell Police Department, where they're saying, live streaming, well, that's not the same as recording. So these officers get off in this instance. And like I said, at least the Fourth Circuit sort of plugged that hole going forward. But the fact that that is the sort of analysis that's taking place will inevitably mean that First Amendment spaces will be where a lot of mischief is able to take place. Because if we've learned anything from centuries of jurisprudence, there's basically an unending way for you to speak and express yourself. And so as long as the court is able to distinguish those cases, you're at risk of being able to have your rights denied, which is really what we're talking about. It's the thing, like, we talk about qualified immunity a lot and sometimes lose sight of the fact that we're talking about everyone knows that Anthony has a right to do what he did. Anthony got arrested and thrown in jail and had his belongings seized and his home searched and was put on trial. And now the Sixth Circuit says, too bad for you. Like, maybe better luck next time. I mean, so his rights have been violated. You can't unviolate them. And qualified immunity means that it doesn't matter in our court system that our constitutional rights are violated. And that should be something that is horrifyingly jarring to anyone who takes an oath to uphold or defend the U.S. Constitution.
And maybe I'll jump in here just as like the person who works at the law school and trying to give some balance to me. So we're like, right, the idea of qualified immunity, at least as I understand it originally, is, look, there's certain discretionary functions that government actors have. And we don't want to hamstring your law enforcement officer who has somebody pulled over by charging them with the full knowledge of, whatever, Fourth Amendment jurisprudence and everything. And we know that there are certain calls that they'll have to make. And like I said before, if we're going to start holding them individually liable, right? So qualified immunity goes to individual liability and not necessarily municipal liability. If we're going to hold them individually liable, there ought to be some sort of good faith basis for, I didn't think I was violating anybody's rights here. And whatever you think of that, I think we can see that it's gone sort of beyond that to, it's folks trying to find somebody who will essentially launder this claim of, we'll give you a good faith basis to say that this was okay. In Anthony's case, right, like a law director and a judge saw that. But I think it was the first oral argument, I believe it was Judge Tapar, was reading through some of these things and saying, look, just like you said, nobody believes that this is really, anybody was really disrupted here, or anybody wouldn't have taken this as parody. So I think just, again, my point is like how far afield we've gotten from, this isn't just a snap decision made in the moment. This was a decision they made over the course of, days, weeks to do something like this. And I think that is not necessarily the types of liability that qualified immunity was originally intended to address.
Yeah, and we're even seeing some sort of movement from the sort of most stalwart defenders of qualified immunity on this distinction. So, like, we've seen various, conservative judicial figures say, well, okay, I get qualified immunity protecting the police officer in the dark of night when it's raining and he thinks he saw a weapon. But when it's a slow, deliberate process, then it makes a lot less sense. If you have time to seek counsel, for instance, why do we need to build in this sort of protection? And so there is some hope that there will be at least that sort of erosion of the worst parts of this doctrine, because Andy's right. To the extent that qualified immunity makes any sense, and I could spend 2 hours arguing about it, that it doesn't and shouldn't exist, it makes the least amount of sense in this space involving slow processes in response to First Amendment rights being violated.
Glad you guys sort of set us up there, because the next kind of phase I want to move into is some of those arguments that we hear all the time, and I'm going to do my best to present them in the way that I typically see them, offered by fraternal order police or municipal leagues at sort of state testimony when this issue comes up. I want to kick it to you, Anthony, just for a second, because I mentioned earlier about this idea of institutions behave differently when we have qualified immunity, and I do want to make sure we pare back. Because I'm curious from your perspective, having gone through as a private citizen this situation with your law enforcement department, then with the judges and qualified immunity, does it change how you view those institutions? Do you interact with law enforcement differently, or because of the nature of qualified immunity, do you look at the justice system or society any differently than you did 7.5 years ago?
I interact with more fear if there's like, because I know that there's this process, there's like this wall. There's a bunch of protected people up here, and the cops are kind of down here, but if they just grab them, they're above this wall, so they can kind of do whatever they want with the reason. So I am kind of afraid.
And if you guys want to chime in kind of on the institutional side before we dive into those arguments in favor of qualified immunity, are there on the policy side incentives changes that you see that change the way policing works or the way that other government officials do their job because of this liability shield?
Yeah, I mean, there's no doubt that, and look, there's no doubt that insulating government officials from constitutional violations will change their behavior in a way that makes them more willing to violate the Constitution, because the cost and benefits have just shifted. And that was one of the explicit reasons why the court created qualified immunity. So there's no debate there, there's no mystery there. Like the Supreme Court, knew that by doing this, government actors would take riskier actions that would be more likely to violate the Constitution. So that's exactly what they're doing. When you see these cases of egregious police abuse, so like, well, I wonder why police are acting like they're above the law. They are above the law. That's why. Of course, there are some exceptions. You can win some of these cases, but the point is that the goal line has been moved, and it makes it very hard to win any of these cases, and a lot of them you will not win. And so that will inevitably have a psychological effect on the people that it applies to.
Just to kind of go back to some of those reasons for QI, I think we've already kind of touched on at least a little bit, unless you guys want to elaborate that, particularly law enforcement is when this comes up. You're going to have to make split-second decisions. It's a uniquely dangerous job. Your life, maybe others' lives are on the line. So feel free to expand on that. But I also want to add on to that an argument that I am seeing increasingly, which is just particularly law enforcement, but all government officials hiring and retention. And the idea that, look, one of the reasons people take government jobs, maybe not the defining reason, but one of the reasons they might take them or accept lower salary than they would in the private sector is because they know that if they're interacting with the public, they have this level of protection. And so you can hire municipal sanitation workers because they don't have to be afraid if they accidentally ding your car that you're going to sue the entire city and then the whole sanitation department's going to get fired. And feel free to address that issue or other examples. But this idea that, look, we've got to hire these people and we've got to keep them on the force, and it's hard to do. Now you're taking away something that they view protects them from potential bankruptcy.
I think it raises a lot of interesting issues. One is like, do we really think that these individual officers or individual government actors, if there wasn't qualified immunity, that they would be personally paying these judgments, right? So there's a lot of talk around, even if this immunity didn't exist, it's not like Officer Smith is coming out of her pocket to pay a judgment for a constitutional violation. You would expect that, at least, in Ohio, we've got statutes that require this. There will be defense and indemnity from that department. So, it's sort of like hair splitting to say that we can't get to a trial on the merits of this because we want to protect against that liability.
Yeah, I'd say two things. First, on the split-second decisions aspect, this is a very frustrating discussion because we hear this more and more talked about as a defense of qualified immunity. And the response is so obvious. Police are allowed to make split-second decisions. They're allowed to make mistakes. Mistakes don't violate the Constitution. What violates the Constitution is doing something unreasonably. That is what the language of the Fourth Amendment says, and that's important in its own right, but it's also important because this concept of reasonableness was the policy judgment that the founders adopted into the Constitution that is supposed to be guiding all of our public servants in their behavior. And so to say, well, you have to act reasonably, but if you act unreasonably, we'll see how unreasonably unreasonable you were, is what we're doing with qualified immunity. Like, these doctrines, in addition to having that escape valve, are already interpreted by the Supreme Court in a way that's very protective to the government. And so the standards for establishing excessive force or determining whether a seizure is unreasonable are very low as it is because of the actual merits of the constitutional claim. So the last thing that the court needs to do is throw on top of that another gloss that doesn't even have anything to do with constitutional violations. And yes, Andy's completely right that basically every state in the country is indemnifying all of their government officials if they ever get sued and are able, and somehow get past these immunity doctrines. Individual officials never pay a penny. And frankly, I think more and more that the argument about that is being made in bad faith. I was just up in New Hampshire testifying in favor of a bill that would fix qualified immunity on the state level there. And we worked on that bill and put in there specifically that only the employer would be liable. So the individual can't even theoretically be liable. And all the police organizations and the municipal organizations still came out and said, this will hurt retention because people are afraid they're going to be bankrupted. And there, the statute specifically says you can't even sue the individual. There's no chance, no theoretical basis, but the same arguments come out to play. And that's because, I don't think the people making them really are concerned about those issues.
Second, I want to kind of move on and give you guys a chance to throw on your reform hats and say in a utopian world what you might like to see happen, along with what is happening, maybe as a New Hampshire example. But just to hit kind of one more point on the sort of dollars and cents argument, I'll throw two out at the same time. One is courts are overburdened. We're already having a hard enough time, finding room on judges' dockets. You're going to flood the court system with a ton of frivolous lawsuits. This is just a handout to trial attorneys who are going to throw everything at the wall to see what sticks. And then the other one is, well, great, let's say we indemnify folks. Well, now the taxpayer is paying the burden, right, or paying the cost. Can municipal and state budgets kind of handle this sort of risk or liability?
Sure. Well, I suppose on your first point, I don't want to be too flip about this, but to me it just sounds like so sad, too bad. Like, I'm sorry that you have these cases on your docket alleging serious constitutional violations, and certainly there are lots of cases that our courts deal with that we say that we shouldn't be dedicating public resources to, right? Corporation versus corporation, like litigating a contract that doesn't handle any of us is a much, I would rather see some of those cases go by the wayside. I don't want to offend anybody in like our business and regulations. We're saying the courts are public bodies and they're here to protect those constitutional rights. And if anything, we should be hearing more of those cases on their merits than less. And I got too fired up on the first point.
The second one was on that. Okay, let's assume you sue the employer or that the individual's indemnified.
Oh, yes.
Now municipalities suddenly
Yes.
have to deal with this. Or taxpayers are now being punished for what one bad person does.
Right. So this is an expansion on this argument of it'll cost us too much. The greedy plaintiff's bar will be here to suck the blood of the public. The reality of the situation is this, and this is something that I've talked to a lot of people in legislatures about, and frankly, it just doesn't land, and I don't understand why. The Constitution exists to protect our rights, and it does that by prohibiting the government from doing certain things. There might be instances in which the government wants to do those things, but the reason we have the Constitution is so it cannot do those things. But qualified immunity allows it to. And then turning around and saying, well, if we allow someone like Anthony to have a remedy for his constitutional rights, that will take money from the taxpayers. The thing that is never appreciated in that moment is, right now, the cost exists, and Anthony is the one who bears it. His constitutional rights are violated, and he's the one who has to pay the cost because of these stupid doctrines. And so when government officials come out and say, well, who will pay for this? They're saying, why should we, the public, pay for violating someone's individual rights when the individual whose rights are violated can pay for it themselves? That's the scenario that we live under right now. And I just don't understand how we can live in a system with a constitution where the most well-known Supreme Court case establishing judicial review said that every right must have a remedy, and that's foundational to the way that our constitutional order works. And now today, in 2023, that's not the case probably more often than not, because you have to imagine, too, for every Anthony who went through all this and found a lawyer and brought the case, there are 1,000 Anthonys who just let it happen to them because it was too difficult or because the state was able to steamroll over the top of them. So it's very important that people like Anthony, who are able to get through all of the other sort of informal barriers that we heard about at the very beginning in the intro, exist to at least be able to have them establish constitutional principles that should apply in a way that would protect everybody.
And even to build on that, like, it's not, even setting aside the costs to Anthony here, which are real and tangible, it's not costless for the municipality to fight a cert petition to the Supreme Court, right? How much does that all cost?
That's such a good point.
And like, and it's even in terms of judicial economy, right? Maybe without qualified immunity, the city comes to its senses and offers a reasonable settlement that will compensate him for these constitutional violations, and we can get the case off the docket, rather than, you know, going to your Supreme Court printer and paying them for all those bound briefs and, you know, waiting at conference and prepping for the argument. Like, all of that will cost so much that it's another bit in the equation.
Yeah, this is worth pausing on because, like Andy said earlier, excuse me, one of the reasons the Supreme Court stated that it was creating qualified immunity was that it wanted to reduce these sorts of costs because it didn't want the government to have to be bogged down in this sort of litigation. So it said qualified immunity is a defense from suit. We don't want a case to go to suit if it doesn't have to. But all of these weird idiosyncrasies of this doctrine make these cases much more expensive than they would be. Normally, if you file a lawsuit, you go to trial within a year or two. Then it's either over or you can fight over what happened in a single appeal. But like we talked about earlier, qualified immunity is special and it can have multiple appeals, which is what happened in Anthony's case. So these cases drag on for years. Almost never in another case would you see multiple appeals, which requires hundreds or thousands of attorney hours and judge hours to do this. And for that to be the scenario, and then have the court say, well, you know, if we got rid of this, it would really be bad for the court system because it would tax it a lot. It just seems laughable to me.
If we have time, we'll get to kind of the state of the broader debate, both in the courts and in Congress and in the states. But I do want to honor the fact that we're at about 18 till. So assuming that would be a longer conversation than 3 minutes, I want to open it up to the audience if you guys have had a moment to think about any questions that you would like to ask the panel.
I was wondering if you could speak a little bit about raising a case in front of the court that decided Egbert v. Boulay and this movement toward proving that you have a remedy for constitutional violations and proving that your rights were violated and just the general movement of the legal field in that direction.
Sure, yeah, so as part of the Project on Immunity and Accountability, qualified immunity is a big chunk of it, but there are a lot of other doctrines that work in this similar way. And a lot of them overlap. And one of them that actually overlaps is something we call federal immunity, which exists in the form of the Supreme Court more or less eroding the availability of any claims against federal officers of any type. So I'm not talking about just federal police, I'm talking about IRS agents or, you know, any other number of federal officers. And the Supreme Court has more or less taken the position now in this Egbert versus Boulay decision that it just decided last term that it's not going to allow claims against federal officers. It doesn't matter how bad or how egregious or whether it was clearly established. And just as some background, until Egbert and still after it, federal officers also get qualified immunity. So you have to jump through this additional hoop when you're dealing with federal officers. And don't get me started on state-federal task forces because it gets even more complicated there. But what the Supreme Court has said is, well, there's this section 1983 that creates the cause of action that you can sue people for acting under color of state law, which was enacted right after the Civil War. And obviously, Congress was focused on bad state action in the wake of the Civil War and the Reconstruction South, which we could talk about. But there's not one that specifically says you can sue federal officers. And so because of that, there's no cause of action to sue them. And we don't think it's part of the judicial role to allow a cause of action. That's something Congress needs to create. This argument makes no sense. Historically, the point of the judicial branch of government was to adjudicate disputes and apply an appropriate remedy. So you don't need to tell the court, hey, you have a right and you can go to court to enforce it. That's what a right is. That's how rights work under common law. That should be how they work under American constitutional law. And so it's very silly, especially because the purpose of the Bill of Rights is to be an anti-majoritarian document. So we have the First Amendment to protect us, not because we're going to say things that everyone agrees with. If everyone agrees with us, we don't need a protection. It's so we can say things that upset the people in power, and they can't go after us. And so for the Supreme Court to then turn around and say that the most majoritarian process, Congress, needs to pass a law saying that you're able to actually have a remedy for your constitutional rights, basically takes the legs out from under the entire Bill of Rights. And there's a million reasons why the court's wrong to be doing this, but it absolutely is doing this. And it's something that we're fighting as strongly as we're fighting qualified immunity, because it has the exact same impacts, if not worse, and we're dealing with hundreds of thousands of federal officers. You could just as easily have your rights violated by a federal officer as a state officer.
If we don't have remedies, we don't have rights.
And that was my apologies. It looks like we have a hand mic, so I will pause after the next person raises their hand. It looks like over here.
All right, while we're getting the mic over here, I'll just say, it also just is completely ludicrous that essentially the state of the law now is the federal Constitution has less protection over the actions of federal officers than state officers. Come on.
So obviously it seems that a complete restructuring of qualified immunity is certainly not on the table anytime soon. Do you think that perhaps requiring courts to at least reach the constitutional merits before deciding qualified immunity so that there is kind of the protection moving forward would be a step in the right direction?
I do. I'm not sure if I have much hope that will happen, just on its own. But I do think that would help develop the case law in that direction for sure.
Yeah, so in the last 40 years or so, the court's probably made a dozen moves that have made qualified immunity incrementally worse. And so rolling back any of those would be great. That one would be particularly good. But the problem with the hope for that one is, in 2001, the Supreme Court decided a case called Saucier versus Katz, where it said, you got to go 1, then 2. Come on, people, that's the numbers, right? And then in 2009, they decided Pearson, and they said, actually, we overrule ourselves in Saucier because we think it should be easier. And so, given that the court has already gone back and forth on this and done so in recent memory, I just don't think that that's a place that we can have much hope for change.
Since we have laws at the state level sort of undermining qualified immunity and allowing plaintiffs to bring, essentially constitutional claims without the risk of getting bounced on qualified immunity, have you guys done any research on how that has affected litigation costs? Are those cases getting settled more quickly? I assume because you're not taking repeated interlocutory appeals, they have to be going, if it goes all the way to trial, that has to be going much more quickly. But what's the overall impression of how that's affected the cost question?
So I don't have an answer because all of those laws are so new that there basically haven't been any great empirical studies on this. All we've kind of gotten are anecdotal complaints from sheriffs and police chiefs about how it's hard to retain or hire new people. There's been no explanation for how that works, and frankly, a lot of the anecdotal discussion is, well, my guys are retiring because everyone hates cops now and because of qualified immunity. And no one ever is like, well, maybe those things are in tension, right? Maybe the fact that there is this sort of immunity is what makes people distrustful of the government because they know that they'll get away with it. But on the question of costs, I have not seen any good empirical work done that says one way or the other how that works, the level of burden it places on the tax system, the sort of judgments that we see. But that is another thing. I mean, the scaremongering that takes place in the context of public funds and plaintiffs' attorneys are all built around the big headline cases where somebody gets a $50 million verdict for something. But that is not representative of how a lot of these cases turn out. There was a case in Virginia that made it past qualified immunity where police beat up a black National Guardsman that they pulled over. And he won his case. He got past qualified immunity, excessive force found, and I think the judgment was for like $4,000. And so if you think that's what's getting all the high-powered plaintiffs' lawyers out of bed in the morning, you've got another thing coming.
I'm really interested in knowing how your case turns out, Anthony. I think in the First Amendment context, obviously, there's a compelling story to be told here. I really feel strongly that I don't want to be remiss in not acknowledging the lives that are lost at the hands of police officers and the pivot that was made in Pearson. I think the name of the case is where you can go to 2 instead of 1 now, and the impact that it has. And I want to call out my high school classmate, Omar Arrington Bay, was killed by the Bedford police in the Bedford jail and his mother fought for a very long time to have some sort of justice because of the loss of his life. He was suffering from a mental health crisis. One, against the officers, the Northern District of Ohio, the trial court found that qualified immunity did not apply to the officers, although it did apply to a doctor in the case. And then the Sixth Circuit reversed in 2017. His mother lives with the reality of that every day, and as long as we have those realities for Black and brown people who are disproportionately affected by police violence, this is a real problem. So I'm really, really interested to see how this strategy on First Amendment and with a different type of plaintiff might play in this case. And I want us to be really aware of the necessary shift here, because the lives of Black people haven't really been able to move the needle.
Yeah, and I think that's a very important point to pause on, and this gets me quite upset. I have a white client in another case that I've been litigating for a decade, and the thing that his attorney told him when he went through the criminal trial for which he was acquitted was, if you were Black, you'd be dead. And 10 years later, we're still fighting these doctrines. And I text him and I say, hey man, we lost again, but we're going to keep going. We're going to keep fighting. And like, I know you're on this journey. I'm on it with you. But I'm sorry that it has to be this way. And, his response to me was incredible, but still it shows you the state that we live in. And he said, when I get depressed about this stuff and the state of everything, I think, well, one, at least I'm not dead. Two, at least I didn't have to go to prison. And three, I didn't get bankrupted. And it's horrifying that he needs to think about things in those terms. But it's more horrifying that he's justified to do so. Because for every person like him who didn't get killed, they didn't find a lawyer. They didn't. And when I say lawyer, I mean a defense lawyer. They went to prison. They took the plea. Then, if they didn't get past... So the point is, there are all these gates in the system. And, we try to find the best cases to dismantle those gates. But we'll never stop. If we win in Anthony's case, I will bring 1,000 cases until we have solved this problem. But it's really, really disappointing that we have to think about cases in those strategic terms.
Yeah, and actually, I did want to call out a case that my colleague Sarah Coulter over here argued last year in the Sixth Circuit. It was called Wood versus Eubanks. We were able to get a summary judgment, qualified immunity reversed for a client who was removed from a county fair for wearing a shirt that said "fuck the police." Right, and it was a dispute between state law disorderly conduct claims and First Amendment protections about those disorderly conduct claims, and we got a great result where the court said you can't look at state law claims for anything other than the boundaries of that statute, and if we're talking about federal constitutional protections, we should look at federal constitutional law where it was clearly established. I was doing some media after we got the decision in that case, and one thing that I couldn't get out of my brain was, I don't want people going around, we clearly established that you can say fuck the police, but the last thing I want is people out there, especially Black and brown people, cussing out police and seeing the consequences of what happens if they do that. So I was, just the context of what we live in, I think it is important to zoom out a little bit and say we've given you this clearly established right. There's still other work we have to do to make sure that you don't end up on the wrong side of a weapon for exercising that constitutional right.
I'm curious about what you're asking the Supreme Court to do in Anthony's case. Are you asking it to change the test for qualified immunity or overrule the doctrine entirely or something else?
Both. Yeah, so this is a cert petition that actually does have as its second question presented whether the court should revisit the whole doctrine of qualified immunity. The first question presented is this issue of how qualified immunity interacts with the First Amendment and whether the court should revisit that in light of Anthony's case. So it can do either of those two things if it grants to hear cert. But this felt like it's not every case that we just take a broad-sided QI, especially given how the Supreme Court's been since creating qualified immunity 40 years ago, but in recent years. But in Anthony's case, it makes a lot of sense because you really realize that if you drill down to the actual foundations of this doctrine, they don't make any sense. And Anthony's case illustrates how that is true.
My question is for Mr. Novak and any registered Ohio voter. Will you sign the petition to end qualified immunity and end prosecutorial immunity in the state of Ohio?
Yeah, that's fine.
Great, thank you.
Yes, and hand that thing around.
Pass them around. You got one?
Hello.
Oh, yeah, take a picture.
First, I want to thank you guys because there's not a lot of groups out there helping citizens who just get boulders pushed downhill on them from the government in instances like this. I think you put it, for every one instance where Mr. Novak's lucky enough to stumble across whoever connected him to an attorney to represent him, you're right, there's probably 1,000 instances where they just gave up. They didn't know how to make that connection. And so I have two questions. One, how do we make it so there's more of stuff like the First Amendment Clinic, stuff like Institute of Justice, so at least the numbers get a little bit better than 1 out of every 1,000? And two, what can anybody do to help grow that number of attorneys, because you only can do so many cases?
You could donate to Institute for
Yeah,
Justice.
Give us money to say that.
One thing that I'll say is part of the reason for 1983 and some of the fee shifting provisions in there is the idea that attorneys would be incentivized to take these cases, and that really gets to the nub of qualified immunity, right? If you're not the prevailing plaintiff in that, then you're not entitled to those fees, and that's where it sort of cuts the rug out from under you. Not sure I've got an answer to your second question other than my quick quip at the beginning.
I think yes, of course, like there are things like if you get rid of qualified immunity, it's easier to win the cases. Then that raises the possibility that you can do this for a living instead of doing it as a charity, which IJ does. The other thing I think, and I don't want to get out in front of my skis here because I'm out of law school, is the cost of going to college and going to law school is extremely high. And if you come out of those institutions with hundreds of thousands of dollars in debt, it's very attractive to go work for a big law firm doing corporate stuff. It's less attractive to try to figure out how to navigate these doctrines that might get you paid 10 years after the fact. So there are other features of the system that are creating problems in this space, but I do think getting rid of these unnecessary policy-based immunity doctrines would go a long way to kind of allowing the market to correct to the point where more people would do this sort of civil rights work, and it wouldn't fall in disproportionate part to nonprofits. But Sabode and friends are here. I mean, there are people who do this work on a daily basis.
But there's not enough.
Well, I don't know if there could ever be enough.
Right.
There's always going to be constitutional violations, and until every single one of them is remedied, I don't think we're going to reach the enough level.
Hello. First of all, I just wanted to thank you for the work that you're doing at IJ, and thank you, Professor Geronimo and Sarah, for the work you're doing at the clinic. If we lived in a world in which Congress could enact a statute expressly overruling Pearson from '67, Harlow, Saucier, Pearson from 2009, do you think that the federal judiciary, and specifically the U.S. Supreme Court, would permit a 1983 claim to proceed?
So in my fantasy world, we would be passing something akin to the Ending Qualified Immunity Act, which is simply amending Section 1983 to say, like, hey, I know we didn't put any immunities in here, but just so you understand, courts, that means there aren't any immunities. And then also...
But would they respect it?
Well, yeah, we're getting there. And then also add the 4 or 5 words to make sure that federal officers are also liable. I think if Congress...
Did you say prosecutors also?
Yeah, prosecutors, all of them. All
Thank
the
you.
immunities go away. Yeah, we'll talk about prosecutors in a minute. I think the court would have no choice but to. I could see at some point in the future them finding new interesting ways to make procedural hurdles. And we see this all the time outside of the immunities thing. It's like that's the problem with talking about this is that at the end of the day, we're essentially talking about very inside baseball procedural stuff, right? And so, to your point, the way that the court could still make things way harder for everyone is the way that it makes things harder for them outside of a damages context by saying, oh, well, the standing doctrine is actually much more robust, and the pleading doctrine requires more and more and more, to the point where you don't need immunities if you just can't even get into court in the first place. As anyone who's litigated knows, you do as much fact gathering as you can before the case, but you won't ever know all the facts. And the more facts that the courts require for you to establish standing or to have sufficiently pled things, the harder it is for plaintiffs to ever go to court in the first place. And so I would not be surprised if we see those things continue to get worse, just because if we're looking backwards as a predictor for how things will go moving forward, it's a pretty strong indication that it will. But I do think that if Congress would do the court's job here and tell them, hey, you know, when you passed that statute after the Civil War, we really meant it, that problem would at least go away. You're right that it might be a whack-a-mole game to some extent, but I think it would take the court a long time if it wanted to do that to make things noticeably worse.
I do have a rule in that I refuse to end panels on pessimistic notes, and so, which is why I never let lawyers finish the panel. And I want to build on your excellent question about kind of finding more ways for people to get involved. So my role at the Institute for Justice is actually on the activism team. And in addition to some of the great work that folks like the Ohio Coalition to End Qualified Immunity are doing, there are a lot of opportunities to get involved at the state and local level. The Institute for Justice has, for instance, model legislation at the state level to create a cause of action. Doesn't address the federal issue, but small steps. And we also have a model ordinance that can work in some states in the appropriate situations at the municipal level when state action is really not possible. So I do encourage you all, if you feel inspired, but you are not in a position to take on a constitutional claim at the Supreme Court tomorrow, don't lose the fire that you feel after hearing from folks today. Feel free to stop by our booth. Go to aaqi.org. That's our Americans Against Qualified Immunities coalition. We work in a variety of states and hoping to work here in Cleveland actually on municipal reform efforts if there's an appetite for that as well. To try to get something state, local passed, whatever we can do to kind of chip away at things from a policy perspective while the attorneys take on kind of the big beast and try to get things sorted out at the federal level. But with that, I do think we are at 1:03, so not too terrible for a panel time to wrap up. I want to thank our panel, Case Western, absolutely, everyone who has supported us and allowed us to make this event possible. In the audience, thank you guys for taking time out of your day to come visit us. Feel free to grab another sandwich if there's any left. I don't want to carry them back. And I hope you have a great rest of your day.
Our top priority